Welcome back. My name is Mark Silver. I've done a series of CLEs over the years on mitigation and forensics for both criminal lawyers and immigration defense lawyers, although I've also worked with civil litigation lawyers on personal injury cases and related issues. After doing these CLEs, I wanted them to be available to everybody, so I've recorded the programs here on YouTube, and they are available. But what I also wanted to do was answer some of the major questions that have come up over the years that I really couldn't answer in the context of the CLEs. Just as a reminder, I've been working here for over 2 decades. I'm a psychiatric social worker with a doctorate in psychology. I'm also a lawyer in New York State, background in political science. I've done thousands of cases that I've written up, but also consulted on countless others as well. As I said, primarily for criminal and immigration defense attorneys, but also for civil litigation. And what I'd like to do going forward is try and answer some of the major questions that have come up. And one of the core issues that I'm asked about is, what do you do if you're living in New York City and you have a referral for a client who's in an ICE detention facility outside of New York? The first thing I'd say is that most of the clients I've seen in ICE detention facilities over the years are held in New Jersey, very close to New York City. And that's because the client's family are either in New York City or in New Jersey. Years and years ago, although maybe not that long ago, it was not unusual to have clients in New York or New Jersey, Connecticut, Pennsylvania, and the client's relative was held in an ICE detention facility in Florida or Texas or wherever. This had huge disadvantages, not only because I could not easily visit the client in the ICE detention facility, but the client could not have his spouse or children or other family or friends visit, and the client became very isolated, despondent, and this went on for months and months and months, being alone so far away, so that by the time the case was referred to me through the immigration defense lawyer, I wasn't seeing someone, who was just newly separated from the family. I was seeing someone who's very, very emotionally and physically detached. And for me then to also see the person through an audio-visual for the evaluation, rather than seeing the person live, face-to-face, was very, very challenging. Challenging for me as an expert evaluator, but challenging for the client who has had so little human contact with friends and family for such a long period of time. There are many issues I want to talk about, but I want to focus on the things that I think have been most relevant in conversations with family members and lawyers. The first, which we have to be very honest about, is cost. The large majority of cases that I see pertain to individuals, respondents, and family members who come to my office in New York City. Obviously, New York is very large, and there's a very large immigrant population here. And I also see clients who travel from New Jersey, Pennsylvania, Connecticut, Maryland, the larger New York or Northeast region. Because the truth is, within 3 or 4 hour drive of New York, there's a huge catchment area. But when the client is in ICE detention very far away, the client can't come. Obviously, if the client's in ICE detention, even very close by, the client still can't come to the office. And the huge issue is cost. It's a reality. It's something that the client has to be aware of up front. And it's not unusual for the cost of seeing a client in ICE detention is double or even triple of what it would cost if they were able to travel to my office either alone or with their family members. And the reason for that is primarily travel. I mean, if I were to travel to see someone in Florida in an ICE detention facility, Florida's not that far from New York, but because of a TSA inspection, boarding, getting on the plane, delays. It could be, a 5-hour ordeal door to door or more, depending on where the client is located. And 5 hours is the greater part of a day. In a number of cases that I've had, planes have been delayed a little bit, but sometimes significantly. And so I'm almost having to charge, depending on the location of the client, in ICE detention, a full day simply for travel, a full day to get there and a full day to come back. When I see a client in ICE detention, I almost always see the client twice. This is different from an in-office visit. I can often see a client in my office for 3, 4, 5 hours, alone and with family members, and get all the information. The problem is that with clients who are in ICE detention, because they've been physically and emotionally isolated, psychologically isolated, it takes them time to feel trust. There may be all sorts of issues. Many clients fear that guards are listening or that their conversations are being recorded. Sometimes I don't feel comfortable for the first, hour or so. I may need some time to feel more comfortable speaking with a client in a cold, dank room. I once did a case north of New York in a jail, and not only could I not see the client directly, it was behind a glass barrier, but I did not have a chair to sit on. I had a stool, which was very uncomfortable, and immediately in front of the glass barrier was an area to place, a cup of coffee or a pen, just about this wide, maybe about 6 inches, or not even 4 or 5 inches. And I couldn't put my pad of paper there adequately to take notes. And I take a lot of notes as I go along. So it's not just that the client has to feel comfortable speaking with someone in ICE detention, but I have to feel comfortable, and it's a two-way street. This is one of the reasons I always tell clients and their families that if I travel to an ICE detention facility, that assume a second visit or even a third visit might be needed. And that second or third visit means, a second or third day of visiting the client, and it means a lot more cost. Staying at a hotel nearby. In many, many cases, I have to rent a car from the airport. And it just adds up. And clients need to be aware of this up front. They have to feel comfortable with the reality that this is going to be a significant cost. But with every significant cost in these kinds of cases, one hopes that there's also a significant investment. And the investment concerns the quality of the evaluation that I can undertake in person visiting the client in ICE detention. It concerns the ability to elicit information that the client may not otherwise be comfortable talking about through an audiovisual link. It concerns very personal and painful psychosocial background concerns I might have about the client, challenges, traumas, abuses, interdependent family concerns, all sorts of things that the client may really only open up about in a very honest and direct way with someone there in the room with them. When you're in the room with them, even if it's a cold, dank, terrible room that you're speaking with the client in, it's still live. It's still very personal. And I have to tell you, the truth is, in about 2/3 of the cases, wherever I'm interviewing the client in ICE detention, it's usually okay. I mean, we have, it's not the Hilton, but, you have a basic table, chairs. It's sufficiently adequate to do a good evaluation. In contrast with audiovisual evaluations, there are two problems. The first problem is the actual quality of the audiovisual evaluation. And if it's a poor link, it's going to definitely negatively affect the evaluation. The second problem is with the internet, how strong the link is. I had a nightmare case. This was about 3 years ago or so. It was during COVID. This was for a criminal defense lawyer. The client was in upstate New York. It was a very serious matter. And the audio visuals were so poor, I ended up having to interview the client by telephone. I couldn't go see the person. It was during COVID. The jail would not permit it, even though the client was more than willing to pay me to go up. And the telephone interviews were extremely awkward. There were very difficult concerns regarding sexual abuse of one of the children. The client had multiple serious medical issues that had left him debilitated. And frankly, I wanted to see the client. I wanted to see the client struggling and his personal issues. And through the telephone conversation, I got a lot of information. It went, I guess, relatively well, but it was obviously inadequate. Most telephone calls to jails have time limits. And I think this one was crazy, like I think 30 minutes or even 20 minutes. I can't remember, but I had to, every 20, 30 minutes, whatever it was, reestablish the phone link. And as you can imagine, maintaining a sense of consistent clinical questioning was a horrible challenge. I recently had a case in North Dakota. This was a man petitioning for his wife to stay in the United States. It was a J1 waiver. And the audiovisual, we did it by Zoom, was great. It was very clear. There were problems with the clients being in the same picture at the same time. It's important because I want them in the same picture at the same time because, the relationship between them as married couples is absolutely central to the evaluation. It turned out at the end of the evaluation, when I'm talking about his health and medical issues, physical concerns, that he was quite debilitated. And he could not cook or clean for himself. He could not easily go into the community for shopping or other basic needs and personal issues. And his wife was doing this for him. She was driving, she was doing the cooking and cleaning, and it allowed him, the sense of independence and personal dignity. The problem was because I couldn't see them in North Dakota, I couldn't fly there in person because they couldn't afford the cost of me going out there. I didn't understand the seriousness of his physical issues until the very end. And if I had seen him, if I'd been at the house and he clearly could not have opened the door for me, it would have been his wife and he couldn't have gotten up to say hello and so on, it would have given me a much more immediate sense of his physical limitations and the degree to which he was dependent on his wife, and it would have allowed me to contextualize the evaluation in that way. Similarly with ICE detention, I see a lot of people who not only have physical issues, but who have psychiatric issues that could be debilitating, limiting their physical abilities, their ability to enjoy their everyday life and care for themselves in a dignified way. And it's hard to pick that up on audiovisual evaluations for clients in ICE detention. I recently saw a woman. She was about an hour east of Pittsburgh in an ICE detention facility. I forget what it's called. And she looked great. She looked like she was, in her 50s. She was well in her 60s. She had taken care of herself. And she looked great. And it turned out she had multiple issues. But, she's a very dignified woman who's always tried to take care of herself. She doesn't want self-pity. And again, this was an issue that came up about her physical health at the very end. And if I had been there in person, it would have given me a much more immediate sense of her physical health. When you do a clinical evaluation, clinical evaluations are called biopsychosocial evaluations. For short, we call them psychosocial evaluations. But they're biopsychosocial in the sense that you want to also include as essential information the person's biological issues, their medical issues, healthcare issues, physical limitations, and so on. And through audiovisual mediums, it's really much more challenging and sometimes, frankly, impossible to fully understand these matters. Some clients are very concerned that speaking in audiovisual forums will disallow true privacy. They're worried guards are listening. They're worried they're being recorded. And they themselves are much more suspicious of themselves. Like, should I really be saying this to the evaluator? Should I really be saying this to my lawyer when I speak to him through audio-visual? Is somebody listening? They're very guarded. They're suspicious. And many clients, and I've seen this in multiple instances for those who have been jailed, they can develop adaptive paranoia. That is, to survive in some of these ICE detention facilities or jail, excuse me, the client develops proactive paranoia in the sense they are always kind of looking over their shoulders. They're quite hypervigilant as a means to ensure that they remain safe. Many clients that also go to ICE detention facilities, by the way, do not necessarily have a significant criminal history that would have landed them in jail. So that they're simply not used to going to jail. They're not used to being confined in this way, and they're extremely cautious for that reason. They're very unfamiliar, and they're very untrusting of even what guards in the jail tells them when they, the guard says, you're going to have a private session now. Please feel free to say whatever you want. And the client will not say whatever he wants because he just doesn't believe that privacy is really available. Trust is a two-way street. It's not just that I want my client to feel at ease. I want to feel at ease. Obviously, the larger majority of clients come within the larger tri-state area, New York, New Jersey, but also Pennsylvania, Connecticut, Maryland, and so on, Massachusetts. And when they come to my office, I have a very comfortable couch, I have comfortable chairs, the client has a glass of water. And in 3, 4, 5 hours, we undertake evaluations and I get a huge amount of information. But, when I see a client in ICE detention, it's usually the case that just like the client needs to feel comfortable, I may need an hour to feel comfortable. I may need an hour to really feel that I'm connecting with the client and the client has sufficient trust that they can open up about very personal and painful issues in their past regarding challenges, abuses, and all sorts of other things. This may mean that multiple visits are needed. It's very costly to go out to begin with to an ICE detention facility. Usually I have to drive, if not fly, because flying is usually faster and more realistic. But I'll tell the client and the family, please understand I will probably require a second visit to the facility, and please understand that I may require a third visit. And if I'm requiring that amount of time, I got to charge for a hotel for 2-3 nights, charging more time for a rented car, which almost inevitably has to be taken from the airport because Ubers are often not available from out-of-the-way facilities and so on. And it becomes very costly and difficult. I often, even going to Florida or somewhere relatively close, the flight may only be 2.5 hours, for example, or 2 hours, whatever it is. But, you go to the airport these days, you have to be there at least an hour and a half before. There's, TSA checking you in and so on. That whole process with the flight sometimes yields, a result until you get off the plane and you get, your car until you get where you need to go. It can result in like 5.5, 6 hours, which is almost a day. And you have to charge, therefore, for almost a day or a day for travel to and from New York or from wherever you are doing this. This is, I have to say, particularly true for me. I'm a criminal mitigation expert. That is, my specialty is criminal mitigation for criminal lawyers, particularly federal cases. But I have another parallel specialty of criminal mitigation for immigration defense lawyers. To my knowledge, I'm the only criminal mitigation expert in the U.S. who also does criminal mitigation for immigration defense lawyers. And in waivers, for example, and almost all these clients in ICE detention will have waivers that need to be done. It's not just proving extreme hardship for family members, which is absolutely essential, but also mitigating, explaining the context for the client's criminal wrongdoing, explaining profound contrition, explaining the person's judgment and issues that got him in jail with criminal issue or multiple criminal issues. And again, this is much more easily tackled through live in-person visits. And I'm saying that because, therefore, when seeing the client, and I usually see the family before I see the client in an ICE detention facility, I've already spoken to the family about the hardship issues, and that takes a day in itself usually. So when I'm seeing the client in the ICE detention facility, I'm not only asking the client about hardship issues for qualifying and extended family members, and maybe even for the client himself, I'm also asking the client about criminal mitigation related material. Why you committed this wrongdoing, when it occurred, why it occurred, the context. Is there remorse? Is there regret? Is there rehabilitation? How do we know there's rehabilitation? What is the client's life like before? What is the client's life now? Is the client a good community family member? Does the client go to church every week? Is the client involved with community or charitable organizations or development and so on? So you're really going to visit the client for two separate reasons in ICE facility, both for hardship evaluation purposes and for criminal mitigation evaluation purposes. When I see a client in my office, I have very long sessions, 3, 4, 5 hours. It doesn't work through audiovisual. Audiovisual, after like an hour, 75 minutes, an hour and a half, 2 hours, it's something about the audiovisual. I just get tired, and I find, frankly, the client gets tired. The client's moving around. I'm moving around sometimes. It's very difficult to maintain long sessions through audiovisual. This is particularly true when there's more than one issue, more than one client involved. If I'm doing a case and the audiovisual is with a couple and the couple also has other family members that need to be interviewed, you're like scrunching them into the screen and you're not really seeing them as independent individuals. And people just don't open up that way. When a client comes here and they can sit on my couch and they're relaxed and I have pillows and there's chairs and there's a comfortable waiting room, it's just more conducive to allowing long sessions to occur. I've had cases in my office, honestly, where I've had sessions as long as 6 hours, and this is sometimes for clients who are unable to come back because they live far away, or they have multiple family members, or it's a very, very complex case, but it's doable. You work for an hour and a half, 2 hours, you take a little break, you work for another 3 hours. I find I can't do that with audiovisual. The other two major issues with audiovisual versus ICE detention visits is that the audiovisual quality may not be very good. And if it's not very good, you're not going to get a good evaluation. It can be choppy for various reasons. The internet link can be poor. And, it is what it is. You get what you get. But if you go to someone and visit them in the ICE detention facility, you don't need an internet link. You don't need to worry about audiovisual. They're there with you and you're speaking to them, one human being to the next. I had a disastrous case. I think I talked about it, I hope not this time, but maybe in a different program, where I had a client upstate New York. It was during COVID and the audiovisual didn't work. I couldn't visit the client because of the coronavirus pandemic. And I ended up having to interview this client for extremely serious issues. It was a criminal mitigation case through the telephone. And I guess it went okay. I have no idea, compared to what I would have been able to have tackled with having the opportunity to see this client who was very ill in the privacy of a room, speaking to him as one human being to the next. Another issue is that many clients want to review documents, or I want to review documents. If a client has multiple arrests, I want to know about the particular arrests, the dates when they occurred, the disposition, and so on. And looking at documents really helps to trigger a client's memory. It's quite common for a client to say, oh yeah, I had 1 or 2 arrests. And then you look at documentation, the client said, oh yeah, I had 6 arrests. It's important to look at each individual arrest and each individual issue, often with documentation, to help trigger the client's mind. Many clients are in denial, or they don't take it as seriously as they should, and I'll point it, I'll say, look, you have 6 arrests, not 1 or 2 arrests. We need to really delve into this in a very specific and detail-oriented way. Similarly, a client may have multiple documents that they want to show me. Often they're not that important, but sometimes they are, and a client obviously cannot do that by audiovisual. You have to be with the client in the ICE detention facility where they can share information and have me look at stuff. And sometimes there's stuff that we can actually read and review together that might be relevant in different ways. So really there are a wide range of concerns, and I'm sorry to say this, but cost is uppermost in the mind of the client, and I certainly understand it. But I try to explain to the client that while cost is important, cost is also an investment. It's an investment in having the forensic opportunity, particularly if it's a criminal mitigation expert who has a specialty for immigration defense lawyers, to tackle both the hardship issues one-on-one with the person in ICE detention, but also the criminal mitigation matters, which are so essential for adjudication purposes with the USAS or the immigration judge, and for the TA to know about. It'll provide a much richer evaluation. It'll give an opportunity to elicit information that is much more detail-oriented and allow me as a forensic expert to write a report that I think is much more holistic and complete for the immigration defense lawyer, so that he or she can advocate for the client in a more complete way and understand issues that might not have been even fully explicated for the defense lawyer, because he or she also had difficulty communicating with the client by audiovisual when the client was in ICE detention. It's also the case that if the client's going to be in ICE detention far away, it's likely that the client's family also don't live close to me. So I've had a couple of cases recently in Chicago, for example. The client was not able to come to me because the client was in jail. It wasn't just that I was flying to Chicago, north of Chicago actually, to see the client in jail, but the client's immediate family members lived very close as well. And so it was really a double advantage, not only the advantage of speaking with the client one-on-one in jail, but the advantage of being able to speak with the client's family members one-on-one, very close to him in their own community where they felt comfortable and where we could effectuate a much better evaluation for the client's benefit. I hope this was helpful. The bottom line is I really, really encourage immigration defense lawyers to consider having the experts, especially if it's a criminal mitigation expert, to visit the client in ICE detention, not only to tackle the hardship issues, but also to tackle the criminal mitigation issues. I know it's costly. I know it takes several days, but these are serious cases. And at the end of the day, they're adjudicated not just based on the hardship, but based on what triggered the need for the waiver or whatnot. And that can only be really understood through a detail-oriented, complete, holistic evaluation with DHS, ICE visits by the expert. Please don't hesitate to email me if you have any questions. I've put my information in all the YouTube programs that I've uploaded, and I hope this was helpful to you. Thank you.